start us with a karakia. Whakataka te hau ki te uru, whakataka te hau ki te taonga, kia mā kina ki uta, kia mā tarata ki tai, kia he aki ana te atakura, he tio, I hoka, I hauhu, ti hei, mori ura.
Okay, tēnā koutou katoa, nā mai haere mai ki tēnei hui, ko Robert Scott Tukaunga. Good afternoon, everyone, and welcome to Hearing 17. This is the final hearing for the Far North District Plan. We started this journey in May 2024, and I'm pleased to see that we've not lost anybody along the way. My name is Robert Scott. I'm the chairperson of these hearings. And this hearing is going to be a little bit different from others, as we have matters that are specifically related to Hearing 17 that will be discussed over the next 2 days. This is being a general sweep up of matters not addressed in previous hearings, as well as matters that were initially set down to be heard in previous hearings, but deferred to this hearing. In that regard, we'll be playing a little bit of musical chairs with the hearing panels, so that we have the correct hearing panel to hear the evidence that has been brought before us. So I note that we have submitters presenting evidence relating to Hearing 15A, rezoning, Māori purpose zone treaty settlement land overlay and areas of interest mapping. Hearing 15B, rezoning new special purpose zones precinct, and that relates to Paradise Found Developments Limited. And Hearing 15C, rezoning urban, which is Victoria, York and Ontario Gallen. Now I understand Ms. York and Mr. Gallen, you are here. Good morning, good afternoon, sorry, and welcome.
Thank you.
So with me for the Hearing 17 component for this hearing is Councillor and Commissioner Felicity Foy, Commissioner Bill Smith, who's also the Deputy Chair of the hearing panel, and Commissioner Alan Watson. For Hearing 15A, which will be tomorrow, that panel will be made up of myself, Councillor Foy, Councillor Hilda Hokiard-Harawira, and Commissioner Siani Walker. For Hearing 15B component, which will also be tomorrow, that will be made up of myself, Councillor Foy, and Commissioner Watson. And for the Hearing 15C component, which is your submission, we are going to have myself, Commissioner Foy, Commissioner Watson, and although he's not here yet, former Councillor and Commissioner Steve McNally. So I hope that all makes sense to everybody. So this is a hearing under the Resource Management Act 1991 to consider submissions and further submissions on the proposed Far North District Plan relating to those topics I've discussed. We have been appointed by the Council as independent hearing commissioners to hear submissions and make recommendations to the Council on any changes to the District Plan as it is notified. As has been the case throughout the hearing process, we're not intending to issue any interim recommendations at this stage, but we will be hearing all the submissions before issuing a complete set of recommendation reports. That said, we will be holding interim deliberations at the conclusion of this hearing topic. And following the conclusion of all the hearings, the panel will be diligently preparing our final recommendation reports for release to the Council on the 31st, by the 31st of March next year. Just quickly, my background is in planning, and I've been in planning since 1992, and I do commissioner work in a range of places throughout New Zealand. Mr. Watson?
Yeah, my background is in town planning, and when I say that I lived in Northland at an earlier time, I won't say when, it was a good while ago, but I do commissioner work around the country.
My background is town planning. I'm a full member of the New Zealand Planning Institute, and previously I've been a staff member, a consultant, and now an elected member, all with a background in town planning.
My background is local authority work, and also I was a politician, and then since 2008 I've been working as independent hearing commissioner.
And just before we commence the topics today, I just want to ask the commissioners, are there any matters of potential conflicts of interest you'd like to declare? No? Okay. So, usually what we do is we invite council officers to introduce the topics that are in discussion today and the evidence that we're going to have presented before us. I think we've allocated about 40 minutes for that, and there's going to be a number of you presenting. We'll hand that over to you in a moment. We just need to just go through a few housekeeping matters, which I'll let Alicia Kate go through.
Thank you. So we are recording today's session, which will go on the website later, just so that you are aware. Please make sure you have your mobile phones off and laptops without the notifications on. Bathrooms are just through here, which you can also get to through going out that door and around. In the event of a fire evacuation, obviously we have 2 exits, and we would gather at the car park where you came in. We are intending to break at around 2 o'clock for a late lunch.
Now, for those people who have not been to a hearing before, I think Mr. York, Ms. Gelman, you've not been to a hearing before? So, okay, well, first of all, please feel relaxed. We like to run these hearings quite informally. Yeah, please, you're welcome. So basically, we will, when it comes to a turn, we'll invite you to come up to this table. You can read your prepared statements to us, or you can address other matters that you'd like us to be aware of. We may ask some questions of you to understand your evidence, but certainly we won't be cross-examining you like lawyers, and we'll be interested in the answers that you give us. You'll see that we all have laptops here. That's because most of the material is electronically, so we're not updating our Facebook profiles or watching videos on YouTube. It's just that your written statements will be in front of us. If you see us twiddling away, that'll be me writing some notes or just getting through things. Right, so I think now we will hand it over to the council officers to present the hearing 17 topics. Who's going to start off?
Mr. Chair, I think it will be Ms. Mackay and Ms. Kim.
Okay. There are your hands.
This works.
Practiced it and it worked, right? Okay.
I'll just back.
That might have been me. There we go. That's you.
Okay, cool. Alright. Hi, I'm Chloe and I'm the reporting officer for key issues 1 through to 8 of the Hearing 17 report that includes topics on integration, mapping, plan variation 1 and other matters. With me I have Jamie Cannon, who's the author of key issues 9 to 12 of the Subtitles report. Great, my computer's lagging. In terms of the sweep up topics, there were 264 original submissions and 540 further submissions. Submissions came from central and local government organisations, local planning companies, area authorities, Hapu and Marae, key interest groups and individuals. The key matters for consideration are interpretation and definitions. This includes definitions with support, national planning standard definitions where submitters seek amendments, other definitions and new definitions or terms. Mapping matters focusing on special purpose zoning, colours and symbology, and zoning of the CMA and Esplanade reserves. Plan variation matters that includes the airport protection surface area rules. It also includes sweep up and general integration matters. This includes matters relating to natural environment matters, new spatial layers and zones, and other matters. And lastly, matters relating to designations. There were a number of changes recommended in this report, including the following key recommendations: deletion of the definition of plantation forestry activity and other constitutional amendments to align with the national environmental standards for commercial forestry and the new terms that relate to forestry activities recommended in hearings 9 to 4. The introduction of new definitions for emergency service training activities and internal boundary to improve clarity. The replacement of low impact design and sensitive water design throughout the PDP. Amendment to the definition of wetland, lake and river margins to include references to new zones and to exclude artificial watercourses, including drains. Minor amendments to the definitions to ensure accuracy, clarity and achieve better integration and alignment between definitions and provisions of the PDP. The removal of definitions and terms that are not referenced or used within the PDP. Amendment to the definition of impermeable surface to add an exclusion. The replacement of significant natural areas with significant Indigenous vegetation and significant habitats of Indigenous fauna throughout the PDP to align with recommendations made at hearing 4. The addition of a new rule across various zones regarding vegetation within the airport protection surface areas. And finally, consequential amendments to the policies and district-wide chapters to reflect changes to zones and spatial layers and to reflect recommendations made at earlier hearings. The key issues raised in evidence from submitters who aren't appearing are the Department of Corrections, who requests that non-custodial rehabilitation activities be a standalone definition to ensure these activities are appropriately captured and enabled within the Corrections Special Purpose Zone. Kiwi will maintain that a definition for reverse sensitivity should be included within the PDP. McDonald's requests that a new definition for restaurants, cafes, and takeaway food outlets be defined, and also seek amendments to the definition of large format retail. Top Energy seek to define the term footprint. Transpower seeks amendment to the definition of sensitive activities by removing reference to activities listed and recommends additional wording. And finally, various submitters, including Foodstuffs, McDonald's, and FNDC, collectively seek the inclusion of missing tables within the PDP. The key issues raised in evidence from submitters who are appearing at today's hearing are Dykes Oakville Boatyard, who have requested the removal of zoning from the CMA near the boatyard at 1 Richardson Street, which is outlined in orange on the image on the slide. This appears to be a mapping anomaly rather than a substantive planning issue, and because the district plan does not administer land seaward of the mean high water springs, removing the zoning does not result in any practical change. On that basis, we recommend supporting the submitter's request to remove the CMA zoning adjacent to their land. Rezoning to open space is not supported because the land is a local purpose reserved, owned and administrated by FNDC. The use of the land is aligned with the purpose of the natural open space zone. The intention is that all local purpose reserves adjacent to the coast are zoned natural open space zone. The site was zoned conservation in the ODP, and conservation zone land was rolled over to natural open space zone in the PDP. And the submitter has not provided any clear reasoning or rationale as to why natural open space zoning is not appropriate or a constraint. With respect to the overview section amendments, we note that the reserve in front of 1 Richardson Street is council-owned land and is not currently subject to any treaty claims. Treaty settlement processes are separate to the district plan. We have considered amending the overview to refer to Crown land only being subject to treaty settlements, but consider this may be misleading, as we understand that typically treaty claims are specific to Crown-owned land, but council land can be subject to treaty claims by negotiation. After reviewing the evidence, I support in principle removing the clause from the natural open space zone that refers to treaty settlement land currently zoned natural open space in the future. Thank you. There we go.
Thank you, Ms. Mackay. So I'm Jamie Cannon. I'm the other reporting officer that provided the sections 8 to 12 of, key issues 8 to 12 of the Hearing 17 sweep-up report. I just wish to remind the panel of the contaminated land chapter. So we have tabled the witness statement to the hearing panel that was provided as a result of hearing 1 recommendations. So panel minute 11 directed expert conferencing between the council and the submitter, which is called fuel companies, which resulted in a new chapter with an objective and policy for contaminated land, which is provided in Appendix A to this document that you have in front of you. And the chapter will sit in Part 2, District-Wide Matters section, under the Hazards and Risks heading of the district plan, with its own chapter, Contaminated Land, which sits next to the National Hazards chapter. So just want to make sure that the panel is aware of that. If there's any questions, feel free to let us know. And then in addition to that, in page 18 of the sweetheart hearing report, we made mention in paragraphs 68 to 71 of the implications of national direction changes on the PDP process and decisions. Essentially, that is consistent with the advice that was provided by Mr. Fisher at 15D hearing in relation to the KFO submission. The advice was that if amendments to national direction come into force before the panel makes its recommended decisions, the effect of those amendments must be considered by the hearing panel. And council is required to give effect to national direction as soon as practicable or as and when directed by the national policy instrument. The council expects the government to provide more certainty on timeframes for implementing and gazette of the national direction by end of November or possibly early December. At this stage, we plan on providing legal advice as part of the written reply for hearing 17, once we know more, essentially. And we do have Mr. Fisher available online today if the panel has any questions on procedural matters or national direction changes.
Yes, I mean, are you anticipating a change in the chapter?
Not necessarily, no, it's more about the implications on the process, so closing of hearings and what that means for the panel in writing their decisions.
Right.
Yeah.
And this is a really mundane question. You suggest that it goes district-wide matters, hazards and risks. CL, will that be the first?
Yes, the first chapter.
Yeah. CL contaminated land, then natural hazards, then hazardous substances.
That's right, but I don't believe we have hazardous substances chapter. But yes, it would. Oh yes, we do have, sorry, we do have a hazardous substances chapter, yeah. So it would be contaminated land first, yeah, that's right. And that's consistent with the national planning standards. And now we'll pass on to Mr. Jerome Wyeth, who will cover off the Weedon Station submission.
Kia ora koutou and good afternoon, Chair and Commissioners. My name is Jerome Wyeth. I'm here as reporting officer for the Weedon Station precinct request, which was originally considered at hearing 15B. Just checking you can hear me okay?
Yes, fine. Good morning. Sorry, good afternoon as well.
Good afternoon. Yeah, so as usual, I'll provide an overview of the relief sought and submissions, the revised precinct proposal from the submitter, my recommendations in the Section 42A report, and some outstanding issues. So in terms of the original submissions, Paradise found development a request that the PDP is amended to explicitly provide for the activities authorised by the existing resource consents at Wirral Station, and that's Wirral Station shown on the slide there. And they requested that this relief is achieved through a new special purpose zone or structure with appropriate provisions that to enable residential development on the identified building platforms. As mentioned, this was first considered at hearing 15B, and my recommendation at that time was not to accept the special purpose zone request based on insufficient information. Subsequent to that, the hearing panel issued minute 32, and that provided a revised timetable for evidence exchange and reporting, including the enabling the submitter to attend this hearing, and they're appearing before you tomorrow morning. And that also enabled them to lodge planning evidence on the 3rd of October, and that was followed by rebuttal evidence, which was lodged on Friday. Next slide, please. So the submitter has revised their request from a special purpose zone to a new Wirral Station precinct. And the planning evidence of Mr. Hook concludes that the precinct is the most appropriate to address the relief originally sought by the submitter. And one of the reasons was the feedback we provided about ensuring consistency with other similar requests that have moved from a special purpose zone request to a precinct. The planning evidence includes proposed provisions for the precincts, with the key kind of provisions being permitted activity rules for buildings and structures, residential activities, minor residential units, and helicopter movements. And consistent with the approach for other precinct provisions being recommended for inclusion in the PDP, the general proposal is that the underlying rural production zone and coastal environment overlay provisions apply except in specified circumstances. So in my 42A report, I support the precinct in principle, but that's subject to a number of issues I identified in my report being addressed by the submitter. And one of the reasons for that recommendation is just really ensuring consistency with the approach that has been recommended for similar requests, including Matica Station and Precinct, as the issues and really sought is similar. So in my view, a consistent approach is appropriate. Next slide, please. So the outstanding issues really relate to the provisions themselves, more so than whether a precinct should be accepted. One of the key kind of outstanding issues relates to Rule 1, so that's the rule that would enable residential development on the identified building platforms. The submitter is seeking a more lenient permitted activity status versus a controlled activity, which has been requested and recommended for other precincts, which was my recommendation in the 42A report. I've also sought for further justification on a number of matters, including the need for a bespoke rule for helicopter movements, further justification on the need for exemptions to the rules in the coastal environment chapter relating to earthworks and indigenous vegetation clearance. The submitters are seeking more lenient activity status when the rules for residential activities and minor residential units are not complied with. So I've sought further clarification and justification for that. And I've also identified various drafting issues with the provisions. Some of it's really just around structure in terms of whether the impervious surface is a rural or standard, but also removing some of the provisions that I consider to be unnecessary, such as P2. And obviously the submitter has responded to some of these issues in the rebuttal evidence that was lodged on Friday, and you'll hear from the submitter tomorrow morning. That's me, thank you. Happy to take questions.
Yeah, when you talk about consistency, the main point of inconsistency is this permitted versus controlled activity pathway, because the submitters really can proceed with what they want on the basis of the consent order that applies to the land. They don't actually need the zoning or the precinct to proceed with what they wanted to do, but they're wanting to have a precinct anyway just to back up and support provisions that have already been approved through a consent process. So it seems to me if they were to have permitted activity status, would be inconsistent with the way that we've dealt with other precincts. Do you see it that way?
Yeah, that's correct. Absolutely correct. And that's why I sought further case justification as to why a different approach is needed for a precinct, which is essentially next door to the landing and Matica, and where, a controlled activity process was deemed appropriate to ensure that those matters can be assessed by council.
Yeah, I mean, if they had permitted activity status, the council would have no control, very limited control over what happened. The controlled activity status just provides that opportunity for consistency with the other precincts that we're looking at, and also it means the council can have some control over what happens on the land, which it wouldn't have otherwise. That's what I take it.
Yeah, I agree, and that's the view that I expressed in my 42A report, and still hold that position essentially.
Following on from that, Mr. White, is it correct that all of these sites are within the coastal environment overlay?
Let's go.
Because I think
yes, I believe they all are. They're outside the high natural character overlay, which is located within the precinct, but all the building platforms are outside that.
So your information and hearing 4 was that any development in the coastal environment will be controlled as well, correct?
Well, yes, subject to meeting those requirements that it's been, it's a residential unit on an identified building platform, an existing subdivision consent that's been subject to a professional landscape assessment to give, certainty that that's been through a robust process to then enable that to be assessed.
So it's likely that any of the development, assuming that all of the sites are within the coastal environment, and we adopt your recommendation to make development on those building platforms a controlled activity, would the matters of discretion for the controlled activity applying to the precinct be any different, or would they be looking at potentially other matters that aren't coastal environment only?
I think they would be very similar. I think the idea here, and it's probably a similar logic that applies to Medica, is that the rule can be more specific around the specific requirements that apply within that precinct. So you've got a general sort of controlled activity rule that applies throughout the coastal environment, and that arguably is sufficient for what the relief is sought for Wirral Station. It's providing them a sort of certain pathway that they can enable the residential development to be consented, subject to making sure that the appropriate conditions are complied with. So I think the idea here is they just want something that's a bit more specific, tied to the development, with links to the overarching objectives and policies. That kind of answers your question.
Yeah, I think so. I mean, because I suspect, notwithstanding what Commissioner Watson said, I can understand the argument for consistency amongst all the other precincts. But I know with Matica and the landing, they have properties that are outside of the coastal environment. So therefore, they would need a controlled activity to at least govern that development. I'm just wondering what your opinion is about this question of, well, you've already got a controlled activity applying to building development by virtue of the coastal overlay. Does it need another controlled activity within the rule framework as well? And what's the argument for that? Because I suspect the submitter is going to come in and say, why are you hitting us with two hammers instead of one?
Yeah, I think that's a valid question. And it was one that we sort of considered in some detail in relation to Medica, but in Medica, that situation is that there's consenting issues outside the controlled activity framework around earthworks and vegetation clearance, which would mean that without those precinct provisions, it would sort of, undermine some of the anticipated development within that area. So I think there's a valid question around whether something in addition to that controlled activity rule being recommended through the coastal environment chapter is needed for Wirral Station. I guess the other thing to think about is we can't assume essentially that rule will be accepted. But I would, I guess there's so that the controlled activity rule here for this precinct would apply instead of that rule 1 that's been recommended through the coastal environment chapter. The question is something more bespoke needed here?
Yeah, that's right. If that rule in the coastal environment chapter applies to all the sites and it's accepted, does it need another bespoke controlled activity in the precinct?
Well, I guess the way they've been set up, the precincts, is that controlled activity rule in the coastal environment chapter wouldn't apply because we've got this bespoke rule in the precinct chapter.
Okay.
So that's the reason. So you wouldn't apply for both, but I guess the question is, do you need something that's more bespoke within these precinct chapters than the general coastal environment rule?
Yes. I think you answered half my question, which is the precinct provisions would prevail over the coastal environment provisions.
Yeah.
Wouldn't be having to apply for two very, very similar controlled activity consents. And then I suppose the question is, does it cover everything that the coastal environment chapter needs to cover?
Yeah. So the relationship.
Happy for us to talk that through. I mean, these would be questions we wanted to put to the submitter as well. And that was just me wrestling with how these provisions sort of relate to each other and which one.
Just for clarity, the intent is that these specific precinct rules for residential developments on identified platforms would apply instead of the coastal environment rule, not in addition to.
And also, too, could you help me understand? I mean, a lot of the provisions talk about a architectural and landscape vetting process. I was unsure as to what organisation does that vetting. Is it going to be some sort of body corporate or some organisation, or is there some council involvement? I'm really not sure who does the approval of the architecture and landscaping stuff that, you know, the suitably qualified expert will provide a report about.
I think we have Peter Hall on the call who might be able to answer, but my understanding is that it differs, right? So for the landing, they've got a separate process to what Matica has, but it's generally goes through a process where there's a, you know, a semi-board that sort of reviews the stuff to make sure that it's consistent with the overall design guides. And the one for railway stations is separate. There's not a design panel per se. It's just a requirement for a suitably qualified landscape architecture to make sure that it complies with the requirements.
Yeah, but who signs it off? Do we know? When they have to prepare a report for
That's
who?
for railway station. It's a suitably qualified landscape architect, I believe, and so that would be the benefit of a controlled activity process, I guess, would that it would enable council to check that that's been prepared by a landscape architect who's confirmed that the building is in accordance with the design guides, essentially.
You know, in theory, you know, just play devil's advocate again, anyone can produce a report, but if no one's actually saying this actually complies with all the covenants and consent notices and addresses the adherence and policy of the precinct, it sort of begs the question, doesn't it, who's going to do the vetting? You've got this really, really robust process, but I don't know who approves it. I mean, that might be something I'll put to the submitter tomorrow. They may have an answer to that.
Yeah. Well, I'll need to come back to you on the more specifics, because it does, as I understand, vary slightly between the precincts that have been recommended.
Yeah, I mean, I'm going into a little bit of detail at this early stage, obviously because we wanted to sort of throw out those questions that we have, and then as we hear from the submitter tomorrow, you know, we perhaps invite you to make some further comment as well.
Can I just follow on from there, Jerome? And I think I know the answer to the question, but in terms of that consent order or consent notice that they're relying on to you know, basically achieve permitted activity, does that include the provision for helicopter usage and the provision for earthworks?
That's not my understanding. Certainly not for helicopter movements.
So they would have.
They are actually looking for the permitted activity rule in reference to the notice to the exemption to the earthworks and vegetation clearance rules is included as part of that permitted activity framework. That makes sense.
Yes, yeah. On the face of it, would there be any reason why they would have a different earthworks provision in the proposed district plan, you know, relative to other sites in the district?
That's the question I asked, Commissioner.
Yeah, we're consistent.
Just following on from what Commissioner Watson's asked, in the precinct, if it's approved, it allows for residential units and minor residential units. Can you find out from the hearing tomorrow whether the existing consent for the houses actually allows that, minor residential units? Because if the assessment was based on only going past what that the consent was.
Yep. But yeah, my understanding is the consent notice does not specifically authorise or anticipate minor residential units.
And I think the precinct also refers to accessory buildings as well. I don't think the consent possibly refers to that either. So if you want to get that answer tomorrow, you can.
Well, thank you very much, Mr. White. We look forward to seeing you again tomorrow.
Thank you.
Be here in person or online again?
I will be here in person tomorrow.
Oh, yeah,
Here, I should say.
Is that the conclusion of the presentation?
I believe so, Mr. Chair.
Any other comments from any of the other council officers? Okay, great. And then we'll move on to the first submitter, which is Macari Trustee Limited, Benson Farm Limited, and Seta 36 Limited. Mr. Hall, good afternoon.
Good afternoon. Just checking you can hear me.
Yes, we can hear you and we can see you.
Thank you. Thank you very much.
We've got your evidence here and we've all read it. However, as usual, please take us through your summary and any other matters you wish to add.
Thank you very much, Mr. Chairman. Thank you for the opportunity to speak today. This will be my final appearance at these hearings, and it's here to talk about a very minor matter relating to the definition of building platforms. And this is simply a matter that came through from hearing 4 in relation to the topic which the panel has actually just been discussing with Jerome, wherein the controlled activity rule in the coastal overlay and the outstanding landscape overlay, there was provision as a controlled activity for buildings on building platforms as described in that rule that have been identified through expert landscape assessment. And that was actually an outcome sought by the submitters I'm representing today, and a recommendation of the reporting officers to those hearings. An aside of that recommendation was by officers was the inclusion of a definition for building platforms. As set out in my evidence, my preference is that there not be a separate definition for building platforms included in the district plan, and that's best dealt with, I suppose, in a self-contained manner within those controlled activity rules, where I sought that defined building platform or buildable area term be used within that. The Section 42 officer's recommendation right of reply in relation to hearing 4 sought that building platforms be defined and made a recommendation that be dealt with. In this hearing, I filed evidence just noting that recommendation hasn't been carried through to this particular hearing, but I suppose just also restating my preference that it not be carried through to this hearing, and that rather than there be a separate definition of building platform, that is simply dealt with within the controlled activity rules of the respective overlays. And principally the issues there I just raise possibly the same issue raised by Mr. Wyeth when he made his original recommendation, that there is the risk here of including a definition of building platform within the district plan definitions, that has spillover effects into other chapters which might not be anticipated. So as I preferred there not to be a definition of building platform, that rule, controlled activity rule, is self-contained in a way that describes building platforms and buildable areas. Really I've left that evidence for the consideration of the panel and officers as to what they propose to do with that still outstanding question.
Thank you very much. I just think at this opportunity, we might give council officers the opportunity to respond. Is this an error, an issue, is it intentional?
I think we had a discussion during the week, specifically in Mr. Hall's evidence, and looked at examples of definitions that might apply. Our initial response was 2 things. One, obviously to listen to Mr. Hall today, and the second observation, I think, was that there was definitions that we had potentially on the table were very open, and perhaps could potentially have unintended consequences given their breadth. We certainly quite happy to listen today, and probably fulsome reply as part of the right reply, I think. But Mr. Hall's one is made.
Okay, so you'd like some time to consider it further. You give us a response either at the end tomorrow or any written writing reply.
Thanks to Mr. Chair.
Yeah, did you hear any of that, Mr. Hall? I hope so.
Yeah, I did. Thank you. Just understood the recognition that there could be unforeseen consequences by including definition across other parts of the plan. I think, as noted in the officer's report, there's that building platform term is used in natural hazard subdivision, horticulture, Cody Cliffs zone, and may be used for different purposes within those zones. I think that's really the art of it, to make sure if there is a building platform definition, it is included, that it covers all those different purposes. As I say, my preference is that it is not, because the particular purpose by which I had sought that term, I suppose, in submissions only related to the controlled activity, so that buildings on identified building platforms where they've been identified through landscape assessment, etc. That rule that was discussed in hearing 4 last year. So yeah, certainly interested to see officers' recommendations on that.
Anything else to add, Councillor?
Well, it's time.
Okay, so look, I think we're obviously just going to wait to see what the council officers come back in their written reply. It might be verbal tomorrow, or it may be in writing in a couple of weeks' time. Any other questions from you? Other than that, thank you very much, Mr. Hall, for your many appearances throughout this hearing process and your conduct and the quality of your evidence and presentations. It's been very helpful. So this is our farewell, I suspect.
Yeah, thank you very much, Mr. Chairman. And I know we've talked about a lot across the course of the last year and a half, and finishing on a very small, minor matter, but important one. You just want to take the opportunity to thank the hearing panel for the nature in which the hearings have been conducted in a very open and informal way, but in a particular note of thanks to the council staff for what I think I've expressed before. I've regarded as a process which has been run exceptionally well and exceptionally easy to participate with as an outsider into the process by way of information access and the like. So particularly thanks to AK and the team for that.
Yeah, no, thank you very much. And we certainly echo those sentiments as well. So take a bow, council officers, AK. And thanks again, Mr. Hall. We look forward to seeing you again in another guise and format soon.
Thank you very much.
Thank you. So we have our submitters in person. Mr. Galvin and Ms. Rook, you've got some other people with you, is that right?
No, so if you're online,
okay, so there's just the two of them.
This is my parents.
Oh, yeah, well, you can come up and sit with them if you want.
Oh, no, they
Hey, come and have a seat up at the, as I say,
my parents are here because they've been in the community for a long time. And
as I say, we try to keep things informal, so please feel relaxed.
Brian's kept it in check.
Oh, yes, we'll have,
You can't leave me here alone.
And we welcome to the panel our first musical chair, Commissioner McNally, has subbed in for Commissioner Smith with this hearing. Welcome,
You need to sit
Yeah, you'll be very well.
Yeah, I'll tomorrow. So can I give you that? Can I give you these as we go?
Yes, of course.
So
Just
this is the first one for the panel, and so again, we'd like this to, the reasoning for this similar to our delay to the hearing, just to be not made public, but it's just.
Okay, so we've got these two, a memorandum.
No, those are a council document. What you're online. Yeah, this is from the submitter.
Oh, yeah, I was going to hand you copies. No, that's
Yeah.
fine.
I'll take one of this for myself. Yeah, I'll take number two.
So we understood,
Victoria?
Was that Victoria?
Yeah.
She is here.
Victoria's here. Yeah, so,
Oh, I see, this is your, the letter that you submitted, why you weren't here previously.
no, this was supposed
I'm
to be
not
here
supposed to be
tomorrow.
here
It's
today.
not supposed to be here today, and it was coming, but we dragged her out because it's very important, and she's going back.
Okay, well, we'll hand it over to you and you can present your submission to us. And we won't interrupt you, we'll let you finish your presentation and then we might have some questions for you, but they'll just be matters of clarification.
Great. Tēnā koutou katoa. Good afternoon, everyone. It's a pleasure to be here. I'll introduce myself, Andre Galvin, property owner of Lot 1 DP 53506, and to my left, Victoria York, so property owner of Lot 1 DP 53506. As you kindly mentioned earlier, Mr. Scott, this is our first hearing, and so we've got a bit of a run book that we'd like to go through. But before we start, I'd just like to do a round of thanks. First to the council for the opportunity to be heard. In the past, we've missed that opportunity. I'd like to thank the hearing panel for allowing us to be heard in hearing 17 due to points noted that you're already aware of. Special thanks to Alicia for all of the administrative activity. It's huge, this undertaking, and every correspondence interaction we've had with Alicia has been key, been very slick. And also to Sarah Trinder, the planning team from council. Sarah's been great in the opt-in process for our guidance and support and appreciation for that. Although we've got a difference of opinion, we can work through the evidence for that. We will start by putting some clarity around the submissions, and then I'll hand over to Victoria, who will give a brief history of the property, because I think it's important from when we purchased it to now and the transition that's happened and where we are. And then we will provide the relief that we've sought again, and then we can have a good conversation about it. And I'm sure there's 20 questions to in front of me to my left there, and we're happy to answer them as best we can. If we can't, we'll come back to the table with answers at a later date, if that's okay. Originally we submitted submission 530, which was seeking partial rezoning and partial move of the high natural character boundary to reflect the landscape itself. We engaged a planner and who suggested that we also put in submission 567, which was for settlement zone. So we had two live submissions. We then prepared evidence to support both of those submissions, and this is where some of the anomalies and misunderstandings through the submissions from various people in the council forum and their feedback of what we're actually proposing for the land. We've had the original submission had a proposal, and it's merely a proposal. We're looking for zoning rechange at this stage and nothing else. The second submission, or the evidence supporting both submissions, then upped the ante on some of those layouts, because we needed to go, what's the density for a settlement zoning? And so if we are going to take both of those forward and council's going to entertain them, then we need to be able to demonstrate from a traffic, from a servicing perspective, that the density could be handled. Now that's not necessarily where we were going, but we wanted to start as far to the left and move back to the right as we could, or the other way. So that's what we did, and I hope that's put some clarity around the submissions and why we have different proposals, indicative proposals in those submissions. Now, early on in the consultation period, which we opted into, we were advised settlement is a no-go for that zone, which we weren't that comfortable with settlement in that area anyway. It didn't make any sense to us. However, we took the advice and we pushed on with it. Happy to let 567 be discounted and removed, and I think that's been think that is the case now. And so we're zeroing in back on submission 530, which is what area evidence supports around traffic, our landscape, and their services experts. So that's the introduction. I'd also just like, on the topic of conflict of interest, I'd like to point out that one of the councillors we've engaged professionally back in the past, specific to this particular piece of property, and so I don't know if that's relevant to disclose that now, or if we need to, if we do it later. But it's Councillor McNally has appraised that property in the past from a valuation perspective.
That was undertaken a number of years ago.
It was 20.
And you've not engaged him since?
No.
Thank you. Thank you for acknowledging that, but we don't think that's a conflict.
Okay, no, that's, I just wanted to point it out. And there's another conflict that we would like to raise that is potentially, I don't know, engaged a planner, a landscape architect who we've subsequently found out was in business with council's landscape architect, and who's appraised this land back in these rezoning in the 2000s and again in this hearing. So we're just flagging that there may be a potential conflict, I don't know, in that instance.
Who is that?
Sorry, probably a question for the submitters, Mr. Chair.
Yeah.
So on the site visit, Melina Absalom said LA4 did the zoning or the recommendation back in 2000 and is doing it now. And as I understand, Melina and Stephen were in business together some time ago, but they're still opining over the same piece of land on the same decision. And so I just want to flag that conflict.
Yeah, I don't see that necessarily as a conflict. I mean, you've both been in separate business organisations for some time since then. Is that all?
I hope I can clarify things rather than muddy the water further. But there have been 3 landscape architects involved in assessing this property that I am aware of, and maybe others. Mike Farrow was the first, Stephen Brown was the second, and Melina Absalom was the third. At one time, all of us worked at LA4.
But
I left LA4 in 1992. Have been running my own business ever since. During my time at LA4, I had no involvement with this property at all. Mike Farrow left LA4 not long after I did, and I know that he was already in his own practice literalis at the time he undertook work on this property. And Stephen Brown is no longer part of LA4 and hasn't been for a number of years, and he's undertaken his, I don't know whether he was with LA4 at the time that they were involved in this property.
Happy with that response?
Yeah.
I just wanted to raise it because it came to our attention.
Thank you for that. I think it's good to acknowledge it. I mean, the resource management swimming pool is a little bit crowded at times, but I think logically there's sufficient there. Thank you for acknowledging that.
Okay, great.
Yes, I mean, as far as I'm concerned, I don't see any issue.
I was at university at the same time as Stephen Brown. I'm not going to say the name was.
No. No, I'm happy with that response, and I'm sure Victoria as well. I won't speak on your behalf, but that makes sense to me. I just wanted to raise it, both those points, yeah. I'll hand to Victoria now to give a little bit of a history of the...
But just before you proceed, I did say I wasn't going to interrupt you, and now
No, that's right.
I just got to confirm, what zoning are you seeking as of today?
General residential.
General residential, thank you.
So I think it's really important for the panel to understand the history of this piece of land and our relationship with it. I'm not sure if any of you have ever seen the film The Castle.
Yes.
But we kind of feel like we're the dad at the minute, Daryl Kerrigan. So we could go through the history if you like. It's just I've tried to bullet point it and keep it as brief as we can. But I think it's really important that we go over it. Kia ora hearing panel, my name is Victoria York and I appear as a co-owner of Lot 1 DP 53506 Harurufu. Thank you for the opportunity to present the history of our land and the difficulties we have faced, which are directly relevant to the panel's consideration of the proposed zoning and overlays. The purpose of noting history. This statement outlines the background of our property, the zoning history as it unfolded, and the significant financial and procedural impacts that have resulted from decisions made without consultation with us as landowners. Following on, there's a short chronology. I don't know if you want me to go through that by points.
We're in your hands, so
okay.
If you think it's going to assist your submission, then we're keen to.
Okay, brilliant. In April 2000, in the proposed plan, the property was shown as general residential in the district plan maps available at that time. 2003, we purchased, whilst living abroad, we purchased Lot 1 DP 53506 as a residential lot, relying on the zoning shown in the 2000 proposed plan. Between purchase and settlement, and without our knowledge or consultation, the land was rezoned to general coastal in the revised plan of 2003. After discovering the rezone, we engaged a planner and opened discussions with the Department of Conservation and the Far North District Council about a potential management plan. In July 2008, our planner advised that there were now no as of right controlled subdivisions and that the next available category required a minimum of 40 hectares, effectively ruling out development. We were advised that had we applied immediately after the zoning change, we might have had a fighting chance, but that pursuing it then would have been a poor use of money. 2011 to 13, draft regional policy statement, proposed regional council consulting, submissions, etc. We had no notification. 2013 to 2016, Environment Court Appeals, no submission made from us as no notification from NRC received. Apparently a letter, snail mail letter, was sent on the 5th of October 2012 to an old address of ours in London, but we did not receive this. 2017, upon returning to New Zealand, we sought new advice and were told to wait for the new proposed district plan to be notified before making a submission, which we did. July 2025, PDP outcome. Our submission thus far has been rejected, and the PDP now zones the property rural production with a high natural character overlay covering the entire site. Professional costs and rates paid over the last 20 so years, engagement with planners and other experts plus rates paid on this property have cost us more than $200,000. Issues we asked the panel to note: lack of consultation and procedural fairness, to change from residential in 2000 to general coastal 2003, and now to rural production with HNC, occurred without consultation with us as the landowners. These shifts have profoundly affected our ability to use and plan for the property. Reliance and timing. We acted in good faith based on the zoning information available at purchase and professional advice at each step. Our decisions, including holding off applications while overseas, were made responsibly and reasonably in context. The significant financial impact, I've already noted. Outstanding information requests. We have lodged OIA requests with DOC, Far North Regional Council, Far North District Council, seeking all documentation, mapping data, advice and consultation records that inform the zoning and overlays applied to our lot, particularly relating to the Transitional Plan circa 1995, the Operative District Plan 2000-2009, and the Proposed District Plan. These records are crucial to understanding how the zoning has evolved and whether it has been applied fairly and consistently. Agency responsibility. If DOC or other agencies have influenced the overlays or environmental classifications applied to this land, then we question why no contribution, compensation, or offer to acquire the property has ever been made, despite the effective private use restrictions now in place. What we ask of the panel, that the panel recognise the sequence of events and reliance outlined above when evaluating the appropriateness of the current PDP zoning and HNC overlay. That the panel obtain and consider the relevant background documents and mapping criteria used by FNDC, the Regional Council and DOC in assigning the current zoning and overlays, and that the panel give due weight to the financial, procedural and fairness implications faced by us as the affected landowners. We have acted in good faith throughout, while paying full rates and bearing significant costs under ever-tightening restrictions. We respectfully request that this context be considered when the panel reviews the zoning applied to Lot 1 DP 53506. We will provide the official information act documents as soon as they are received and are happy to supply copies of invoices, correspondence and expert reports if the panel wishes.
Thank you.
Thank you.
I want to see if we have any questions for you. Your evidence was very clear.
Thank you.
As far as I'm concerned. I'm sorry you feel like you've had the runaround, but we're here to listen.
Yeah, no disrespect to what you've had to say to us, but just putting that to one side for the moment, what is it that you want to do on the land at the present time?
Well, that is in the next 3-page document, which I'll hand out now.
Commissioner, Council, one question, please.
Have you done an application to connect to sewage, to council sewage, and has that been approved by the Whanau District Council?
No.
No application in as yet. We've had, as part of our expert evidence, we've started the process to say is the capacity, and we've been waiting. We've got some feedback from Sarah during the process that there is capacity potentially, but there's been no application to connect in at this stage.
There hasn't been a reason to, because we haven't known what we can do with our piece of land.
So I think that's a key question that we have with staff as well, given the request to be zoned residential.
Yeah.
An important aspect of that is to have connection to regulated service.
Well, according to the 3 waters that council did in regards to this land, apparently there is capacity.
I'm not sure that, well, the question actually, Commissioner, what is the question you have? Whether they do or don't have a connection?
And whether council's infrastructure team have approved it.
There's been no approval. We've informally asked.
So in terms of approval, do you mean certification or whether there's available capacity?
In terms of available capacity, number 1, and see if the infrastructure staff understand the stringent short comment on that. And then also in terms of actually applying to connect as well would be the other aspect, because I can't see any expert evidence that relates to infrastructure capacity or
Council
services.
Council did that in regards to.
Yeah, so sorry, there is no evidence in relation to infrastructure capacity. There was a peer review of the infrastructure report that they supplied, and that indicated that it could be worked around. And I can provide that to you. It's in the report.
Sorry, I didn't quite hear that last statement.
I will just pull it up. So to the right thing. It's actually attached to the hearing 15C, section 42A report that you can remove from WSP.
Okay.
Just pull it up.
Yeah, could you just give us a quick summary of it? If you can remember.
Essentially, it is viable, but it wasn't assessed. Low pressure wastewater systems with groundwater pumps connecting to FNDC infrastructure could be an option. So there is potential connection available.
Okay.
Just one thing I want to check with Ms. Trinder. What was the development capacity that they were assessing when they responded to that?
They were reviewing the original infrastructure report provided by the applicant, and that was for the larger proposal.
Same zoning, no?
It is the proposal that's there.
530, which is residential and rural residential. The remainder, well, the remainder was yet to be discussed, but the original conversation was leaning towards potentially a rural zone of residential of some description. But I think
Which actually doesn't make any sense when you look at the mapping, but that's what we're going to get to next.
So to answer your question, no application for services, but the due diligence we've done with our experts have suggested that there's capacity, and then we've had that played back to us from councils to suggest that there is potential.
Okay, so.
That's
no
your
further
next
questions
part,
at this
part two. Part two. Do you want to do this?
No, you can.
Okay. Okay, this request for rezoning to general residential and removal of high natural character overlay. Introduction. We respectfully submit that Lot 1 DP 53506, Whakatona Road, Haruru, has been incorrectly zoned and overlaid in the proposed district plan. We request that the rural production zone and high natural character overlay be removed and the land rezoned to general residential, consistent with its location, history, and the National Policy Statement on Urban Development. The site lies within the functional Haruru Paihia Urban Environment Tier 3, directly adjoining existing serviced residential areas. Key issues we have. Parcels have been used outside the SA2 boundary. The FNDC Growth Capacity Report includes parcels outside the Haruru SA2 boundary, inflating housing capacity figures and concealing the true shortage of zoned residential land within the SA2 itself. Under the NSPUD, capacity assessments must be accurate and spatially consistent. Lot 1 DP 53506 sits within the functional Haruru urban area and must be recognised accordingly for future residential capacity. Natural hazard overlays. The same report concedes that natural hazards were not fully assessed in the capacity report. Lot 1 DP 53506 has very low hazard risk as per the engineering report. The site has been rezoned rural production and overlaid with HNC despite immediate proximity to existing residential zoning, manageable topography and accessibility, its luck rating 6 non-arable. These restrictive layers unfairly limit development potential, reduce feasible housing supply and contradict NPS-UD Objectives 1 and 2, which requires council to enable well-located urban growth. Planning and policy context, Resource Management Act 1991, sections 9 and 85 uphold the principle of reasonable use of private land. Restrictions must be necessary and proportionate to proven environmental effects. NPS-UD, Policy 1, urban environments must enable communities to meet their wellbeing needs. Policy 2, councils must provide sufficient development capacity in Tier 1 to 3 urban areas. And Policy 8, unnecessary constraints on development should be removed. Section 32 RMA, any overlay or zoning control must be evidence-based and demonstrably the most efficient and effective means of achieving the Act's purpose. In this case, the HNC and rural production classifications lack evidence of necessity and are therefore inconsistent with both the RMA and NPS-UD. And most importantly, and one of the most important things, is equity and fairness. Neighbouring and nearby properties with similar physical and ecological attributes retain residential zoning without an HNC overlay. Applying these restrictions only to Lot 1 DP 53506 creates inequitable treatment and undermines consistent fair planning practice. This property has the same natural character as adjacent residential land and should be treated accordingly. Positive outcomes of rezoning. Reinstating a general residential zoning and removal of the HNC overlay would enable a residential subdivision within an existing service growth area, support local housing supply and affordability for Paihia and Haruru, promote compact, efficient urban form, reducing pressure on rural land elsewhere, make best use of existing infrastructure and services, achieve balanced development, support both environmental integrity and social wellbeing. The relief sought is that the hearing panel remove the high natural character overlay from our lot on the grounds of equity and fairness and rezone the land from rural production to general residential, consistent with its historical residential zoning, the surrounding urban context, its accessibility to urban nodes like Paihia and Kirikiri, the objectives and policies of the MPSUD and RMA. Conclusion, our lot represents a logical, well-located and low-impact opportunity for residential development. Maintaining the high natural character overlay and rural production zoning is unjustified, inequitable and inconsistent with national direction on enabling growth in Tier 3 urban environments. We therefore request that the hearing panel rezone the site to general residential and remove the HNC overlay, restoring fairness, evidence-based planning and alignment with both local and national policy objectives. Thank you.
And is that all the presentations?
That is, you've got all our expert evidence should be with our submission. So with the original submission, so everything that we've had experts contribute with should be as part of that.
Yeah, have you looked at any lower forms? I mean, the papers talk about 44 lots potentially from the land. Have you had a look at, it might remove some of the obstacles that are tossed up by the council's traffic consultant and landscape consultant to look at the lower form? In fact, was Ansel suggest that as one way forward?
I think actually in the statistics paper about the economics of the far north in general, I think the areas desperately needs a very amount of houses, whether it's a 1-bedroom or 2-bedroom, and they could necessarily be attached. How we go through that, I'm not sure, but I do think it's necessary. Haruru itself, is the population over the last 20 years has increased by 74%, and that's within the boundary of the SA2, and the land that council have proposed is outside of those boundaries that they've included in the calculations, and include rural production zonings and mixed use. Again, are outside the SA2 boundary.
Also, to answer your question, we have considered, in one of the earlier plans, one of the proposals was to have a reduced lot size, but as Victoria said, it sort of complicates. When you look at the zoning, when you look at the map, and you have a look at that block of land, and you put the overlays in and off, residential makes perfect sense.
If you look at it I was going to have this prepared, but because of instance I couldn't avoid. If we had the map up there, we could kind of point out exactly how it looks for the area.
This map.
Yes. If you put up in the ISO plan, we can show you the comparative properties around.
It's also worth noting we engaged, and I don't know if this is the right time, I guess, we engaged NZTA some time ago and have written confirmation that they would accept 3 as is, and that to go for a rezoning we would need to obviously follow the process, but they weren't against it with the right mediating action, right remediation. And then when we called NZTA this time, because of Hearing 14's request to engage transport if you're on the highway, we did, and the initial conversation with the representative from Waka Kotahi, they were very surprised that we were reaching out if we didn't have a consent to talk about, and she was confused. It was the initial one, and then after that, it was basically put a barrier up to give us more work to do that, which we believe is at the next stage, to say, hey, look, you can't get on the state highway unless you follow X, Y, and Z. In conversation with Waka Kotahi representatives in about 2020 as well, that bridge was supposedly on the runway, but funding was the question. And there was conversations about remedial action that we could take to get a volume of cars on and off that road at that area. And then while we're on the theme of traffic, we own 42 Golf Drive, and with council some 20 years ago, there was conversation about using our right-of-way to the rear section to expand that to actually service 13 or 14 lot subdivision based on the purchase of residential and going back to general coastal. So we have considered lower volumes, but our starting position, well, our revised starting position is, we think back to what it was in the early 2000s. Council recommended it to be residential, and we don't see any reason why it shouldn't be. We've got coastal overlays to protect the beauty. Yeah, and so that's the mitigation on, you know, on landscape perspective. We've got terrain, which is a constraint as well. So some of the terrain will mean it's, you know, it's part of it is unusual. And so yeah, so we're going back to where we first started, pretty much, and we kind of want to work our way through that. And we've, as we've gone through this process, and as Victoria's dug deeper and deeper, we now want to get all the information so that we understand the starting position. And then if the information tells us such that it has been done,
bad luck,
then we, you know, we need to then just reassess our situation and what are we going to do. But
we do feel in this process somewhere there could have been a mapping issue and an overlay issue along the journey, and so that's why we've asked for the Official Information Act with DOC has got a request with them and with FNDC, because I think it's really important we understand how we got from here, purchasing a piece of general residential land, to pretty much with these overlays it being completely still. And if people say you can go for a management plan, well, that's just more cost, more complication. We kind of poop when it comes to that. So if you bring up, I don't know if anyone can bring up the map on here, but I can point out the different.
And we're talking about the map in your submission?
No, the map in the ISA plan, so the proposed district plan.
Yeah, I've got it up on the screen. It's the district plan, isn't it?
Like the
district. Yeah.
While they're doing that, did you say you owned number 42?
yes,
Now that, just looking at that, it looks like it's in two.
it is. Yes, it
cross
is.
lease, or
No, it's two titles.
you own both of them?
Yes.
Yeah.
Yeah.
Have you considered using that potentially as access?
Well,
Yes.
that's the way when back in the early 2000s, when Transport New Zealand at the time suggested we could have 3 off the bottom without doing anything, so they signed that off. We've got the paperwork to demonstrate it. We looked at 42, and rest in peace, Ian, the real estate agent who sold us the land was he was distraught when he found out that they'd sold a residential piece and it wasn't actually residential, and so he was doing his level best to try and help us resolve the situation as well. He found 42 with the right of way, and we had lots of conversation with council, Department of Conservation, Ian, planners, to say, can we use 42 to get a number of lots off? Now, there was going to be some concession to widen it at either end, because it's not of the width that's allowable, and then also, you know, subject to if you know, payback, the house could be moved, you know. 42.
Well, it seems to me that would have to go to probably the entire width of that property to make it work.
Yeah.
Having said that, I mean, obviously, Mr. Kelly's traffic assessment, and he's obviously focused on the state access of the state highway.
He has.
And there are some issues there with obviously sight lines and proximity to the bridge.
Yep.
But there is also that other opportunity as well. So,
correct. Yeah.
I mean, I suspect the other people on Golf Drive may have a view on that. I think that's potentially an option.
Yeah.
So
I think with all of those things, you know, once you understand what it is, there's paths to remediation or solution, right? You've only got to look at locations, and I know it's a different zone, and I know it's a different speed, but you know, Bridgewater, it's in there, it's straight on the road on a bridge, and it's on a blind alley. You know, and I've had so many near misses pulling out of Bridgewater. You know.
I suppose one of the issues that you've got is that the title looks like it's landlocked, but obviously it does have a connection with the state highway. And if you take into consideration you own number 42, in theory it has a connection to Golf Drive. Is that
correct?
Are you evidence?
Yeah, yeah. traffic is workable, would be our summary.
Very clear.
I just had a supplementary question to number 42 Gulf Drive. The width. What is the
Of the
what
driveway?
is the dimension of the title?
Oh, so the width of 42, and I'm guessing here is probably 25 metres.
25 metres.
Yes, and then it's got a driveway on the right-hand side that services the rear section, and that's 3.4 or 3 metres at the house width, and then it widens at the end, or it can widen at the end. So, but the 42 is 25, roughly 25 metres. If we just go back to 2000 again, if we can cast our minds back, and apologies for this, when we look at the committee's deliberation and reasons for saying, hey, it's not residential now, it's going to go to general coastal, it also says the land is zoned coastal, which has a minimum lot size of 20 hectares, and this is clearly not 20 hectares. So we're just a bit confused as to why that was, you're sort of contradicting the own. It's an own goal, is how I would sort of say it, from a council perspective, because you're contradicting your own rules. And with DOC, we've got correspondence, and I just need to double check and refresh this, but the main concern was the estuary and protection of the estuary was DOC's main concern, as far as I understood it at the time. And as part of our proposal and submission, we're obviously going to be gifting a boardwalk to the community to get from State Highway 11 round through, and then if DOC and council are prepared to offer up the land that joins our property to Causeway, then you could put in a beautiful structure that gets people off the State Highway walking up. They've now fixed it, but it was an abomination for a walker to go along that estuary's edge. And they're all parts of the things. Now, going back, it's never been our intention to do anything but a beautiful use of that land, and that hasn't changed. We're not overnight developers. We can see that we're 22 years into it. We've brought up a family in between, and now we're back, and now we want to do something beautiful with it. And we feel that, although I do appreciate Malene's comments in the second submission after the site visit, where we could work with something. We just feel that there's been too much of a no, potentially through experts and through council when we've asked, and we're looking for some yeses, pretty much is what I'm trying to say.
And just as a broad question, in terms of your relief, obviously you've stated very clearly you'd like the financial character open and removed, and you'd like general residential. If we were minded to recommend another zone for whatever reasons, and I'm not showing my hand here, I just wanted to know whether you would accept other forms of zoning or.
I don't think it makes any sense. I don't think it makes any sense.
General residential and the removal of financial character are sort of bottom lines for you.
Now we're going to show you a hand straight back, right? We'll take.
You're more than entitled to stick to.
No, and
whether there was any other scope you wanted to.
Well, the thing is, we see it as.
And I'm not asking you to concede.
No, I get it, and we won't concede. I think is probably our hand. We'll go as far as we need to go, but we need to get the coffers filled up with resource to be able to do that. And that's why we're representing ourselves today, because we've spent a load of money, and we were gearing up for a hearing that we were never in. There's a number of things, but we will fill up the resource coffers, and we'll go as far as we need to go. We're not unreasonable, we would concede. But we want to make sure that we're all actually making a really informed decision. And we think that there's potentially some stuff that needs to be bottomed out before we're comfortable that we say, yes, it's all followed the letter of the law.
And just so you're fully informed as to what happens at the end of this process, if you don't get the relief that you request, you understand that you have full right of appeal.
Yes.
Correct. Environment court. Just want to make sure that you know you will write through. We haven't got a lawyer here advising you.
Thank you.
So I think we should just acknowledge that whatever decision or recommendation that we give to council, and the council accepts that, then you have the ability to appeal with the environment court.
Yeah.
They generally try to resolve them before actually getting into a court. So it might be an opportunity.
That's what we were trying to do with Sarah, and there's no criticism of Sarah and team. Everyone's got to do what they've got to do, but we do feel that we can take this a bit further in conversation, and that's what we're doing basically.
Well, I think your comments today have been really, really helpful for us. I think you've given us a really, really good summary and context. It's an odd zoning, and I think everyone probably acknowledges that rural production zones are a bit of a funny fit for this parcel, and I don't think anyone expects it to vegetate to be clear and cows to be rural production to be there, but it obviously it's a piece of land that's trying to find the right zone.
Yeah.
Shouting out.
Any other questions? I think Commissioner McNally might have a question.
Yeah, just with your ownership of 42 Golf Drive and the two titles, if I understood your numbers correctly, potentially you've got a 28 metre wide access strip in there, which means you'd have to remove the house, I guess, to be able to do that.
Yeah.
Have you looked at access back from that settlement onto State Highway 11 and what might be required there?
Back from
State Highway 11.
If you came out of 42, out of Golf, back onto
State Highway 11, yeah.
Yeah.
Well, that's our preference, right? Access off State Highway 11, and that's where we engaged Peter Kelly.
Yeah.
Is that what you're referring to?
Yeah. So that intersection into the settlement along the top of the ridge there, off Highway 11, going into, and then you
into York Road.
Yeah.
Yeah.
Does it currently have a right turn bay and a left turn slip to get in?
From York Road, no.
From the highway.
It has a right turn bay into
So
York
you're
Road.
tight the intersection there now. I'm just wondering what additional hurdles you're going to have to jump to.
So it's got, so when we,
Are you
The
talking
first thing
about
that's
this
happened-
area down here?
No.
Or are you comparing it to?
up the top,
Yeah, that one
No.
to the top where you
Come-
go into
come back.
Berry, off Highway 11, off the top,
Yeah.
right in there.
Yeah, okay, that's York Road.
yeah. So,
I think it does have a slip.
It doesn't.
it does, it does. You can pull to the right and it does have a slip. There is, and I think,
Certainly pedestrian.
I
It's a
think to
passing
Peter's
lane.
evidence, there is potentially space down near our area to,
Down near the bridge.
yeah, and remember, we go 50 metres beyond the bridge, which takes you further up. And with a little bit of manipulation, you can actually get off further up. And there's some good brown stone in there too, because there used to be a quarry.
Yeah.
Yeah, I know. It was a long time ago I was there, but I do recall.
Yeah. And some people in the community have said that brownstone's great. I'd love a bit of that. But that was years ago. There's still some there.
You know, I was just wondering how you, so the question just related simply, if you move the house, you can get in road width.
You can get off. You can get off up the top. Yeah.
No, that was, thank you.
Yeah.
Any questions that are coming out of council officers following that exchange of questions and evidence?
I've actually got Matt Collins online here, our council transport expert, and he's just been messaging me. I wonder if we just give him an opportunity to talk to State Highway 11 access. That would be helpful.
Yes, thank you.
Got him, Matt.
Good afternoon, Mr. Collins.
Good afternoon, Commissioners. Nice to see you all again.
So you've been listening to this evidence. Have you got any comments for us?
Yes, so look, I've got some fundamental concerns with the access onto State Highway 11. I've covered that off in a memo, which I think you have seen. I'm happy to discuss that if you wish. Regarding the presentation today, look, I certainly appreciate the complex history that the submitters have been through. In terms of if the site could be accessed from Gough Road via 42 Gough Road fundamentally, I don't think there'd be any transport concerns with the intersection of York Street and State Highway 11. I think that that's appropriately formed. There would be some complexity using 42 Gough Road to access the site, but you know, I think that that could be managed through a resource consent process. It's certainly not something that would normally be acceptable, I think, but given the complexity of the site's history, I think that's something that I could help council work through some of the details with that.
Okay, thank you. Well, thank you for clarifying that issue about Gough Road. I just wanted to put it to you. Are you prepared to provide us a quick statement in writing that 42 Gough Road is offered as part of your submission? In other words, that access from 42 Gough Road can be considered an offer.
We'll more than happy to put that as an offer, so long as part of that offer we don't stop the progressing trying to get off State Highway 11, right?
But I think that's what you're not necessarily removing State Highway 11.
No, we
option.
No.
But what we just like to have it confirmed that it's direct access from Gough Road via 42
is available.
It's in your ownership.
Yep.
And then you're offering it as part of it.
We can put that in writing.
Also clarity around the title width.
And confirming the width
We can give you the whole
by the title documents.
Yeah, thank you.
And we can
request that information as soon as you can possibly provide it, rather than email from the termination.
Yeah.
Just a question for Matt Collins. Mr. Collins, you used the word complexity 3 or 4 times in the short statement you just made. What is a complexity in traffic terms, but more particularly, what's the complexity around using off-drive as access to this land?
Yeah, a good question, Commissioner. So I haven't investigated 42 Gough Drive in any detail. As I understand it, it's quite a steep site. So one, it's a steep site. Two, from what I have heard today, the location of the house on the site limits the width of an access way that could be provided through there. So essentially, it's going to act as a one-lane access way for at least part over that 42 Gough Road. So the complexity is that you would have opposing traffic movements, so you'd need some form of give-way control. You'd need to ensure you've got clear lines of sight over that section so that drivers coming in opposite directions can see the full length over that one-lane section. Given if it would probably, well, almost certainly need to be retained as a private access way rather than being vested as a road, unless the house was being removed from the property and the engineering standards have minimum road widths. At the top of my head, I think it might be 15, 16 metres boundary to boundary. So hence it would need to be probably kept as a private access way. The other complication is a road, it can't be vested as a road if it is steeper than 1 in 8, which is 12.5%, and that's a requirement from the Local Government Act. So if the site was rezoned as residential and access was only available via Gough Road, and appreciate the submitter's comments about not wanting to close off the opportunity for access to State Highway 11, but I do have some fundamental concerns with it. So assuming everything is coming off Gough Road, it would have to, the whole site would have to be served by a private access way, and just with a bit of complication to manage over that 42 Gough Road. But I don't see it as anything that can't be worked through a resource consenting process.
Any other comments from council?
No.
Oh, okay, well, thank you very much.
Sorry, can I just point out one thing? Can you just bring that map back up? So this particular property here
it's residential. Look at the financial character over there. This too is in coastal, but it doesn't have a financial character. In fact, we're the only privately owned piece of land with a full financial character overlay. These guys can come off the state highway and they've got a one-way roading system which comes out at
You're up the top.
up the top here, Ash Grove, I think, and that's how they've gone in one way and they come out, and that's how they're developing this area.
Onto the state highway.
Well, onto Ash Grove, which is straight to so it's off the state highway, onto Ash Grove, and then out onto the state highway again. So a similar idea could happen with that, in our humble opinion.
And just while you've got that there, I'm correct, aren't I, Victoria, that the section down the property down the bottom is part of the coastal overlay?
Yes.
So
these two across the road, on the other side of the state highway.
So we're mirrored properties, as far as I understand it. However, one's got diggers in there now and clearing pretty much everything with a one-way system that comes off the state highway and onto Ash Grove and on. We're the other side of the road, surrounded by residential, and we can't do a thing.
Very limited.
At the moment, except pay rates. We're allowed to pay rates.
Well, thank you very much.
Thank you.
Thank you for having us.
Your attendance, your perseverance. I wish you well for your ongoing health issues and treatment.
Thank you.
And what will happen is that the council officers will get the opportunity tomorrow to give some response to the evidence presented in 2 weeks.
Yep.
And then in what we loosely term a couple of weeks' time, the council will provide us with a formal written response to the evidence that they have received and whether they have changed their recommendations and if so why. That will be put online and you'll have every opportunity to review that, and then we'll be writing up reports. This is our last hearing, so decision writing or recommendation will be writing furiously from tomorrow onwards.
Okay, great.
Thank you very much.
Is there any? Oh, you go.
Sorry. Do you want any information from the official information as it is returned to us? Because it will be another few weeks. Is there any of that we think will support or is of any interest?
Yes, I don't think we necessarily dispute any of those claims.
Okay.
Obviously, we're wanting to recommend a zoning under the circumstances that apply.
Yes.
That we're required to have regard to.
Yeah.
But it's helpful information. Obviously, we want that further information that we requested from you.
So I'll give a letter about what have you got driving?
Yes.
Yep.
And if you could provide that to us
as
soon as you possibly can, that can feed into the information that council will be considering, office is considering, of course, we'll be having regard to that too. So again, thank you very much.
Thank you.
Just to note that we can do a site visit because close proximity there. Have a look at actually number 42.
Yeah. More than welcome.
Yes, we might just, I don't think we need to go tramping through the property.
You are more than welcome.
It's a lovely walk.
We would certainly go and have a look at number 42, and obviously we drive past there.
Yeah, you do.
We've driven past there frequently.
Well, you're more than one.
But we might do it slightly slower.
Thank you very much.
Okay, well, thank you for your time.
Thank you. I think that takes us to the lunch adjournment. We've got 1:40 at the moment. How long do we want to have lunch?
Our next submission is due at 2:45. Thank you.
2:45, so we'll do it now. And we'll be back with them, so we'll adjourn till then.
Okay, stopping recording. And